Now, the next speaker is Aimee Kinder. Aimee's relatively new at the bar. She's currently reading, and her areas of practice are insolvency, corporations law, and regulatory work. Now, her areas of practice really reflect her experience before she came to the bar. She's been admitted to practice for the last 10 years, and she has spent 3 years as associate to Justice Mandy, as he was, when he was in the managing the corporations list and the Victorian Taxation Appeals, and also when he was in, well, I think those are in the Commercial and Equity Division. As well as that, she was a solicitor at ASIC, and she would appear from her background to be eminently qualified to talk on enforceable undertakings, and I invite Aimee to come and speak on her topic.
Thank you, Your Honour. I thought I'd start by saying that obviously, as David's paper made clear, all undertakings are in some sense enforceable. But I'm talking today specifically about enforceable undertakings as that term is used in a variety of legislative regimes. Just gauging where to pitch this, I was wondering if people would raise a hand if they know what an enforceable undertaking in this sense is. Excellent, okay, so a mixed bag there. All right, so it's just to say it briefly, it is a written undertaking that's given within the context of a particular legislative regime. And it's a remedy that's available to an increasing number of regulators in Australia and has proven to be quite popular. I was tasked with talking about enforceable undertakings generally, and that's what I'm going to do, but my focus is going to be on the ACCC and ASIC, because not only are they the regulators who've had these powers the longest, but also they operate across so many different industries that seems to be the most relevant to at least some aspect of most businesses, and of course being the regulators that I am most familiar with. I'm going to go through my paper rapidly within the half hour available, but it does sort of, to give you some idea where we're going, I'm going to have a look at a brief history, the particular legislation that applies to the ACCC and ASIC, the features of an enforceable undertaking and its function within a regulatory regime, and also have a look at the policy of how ASIC and the ACCC exercise that power, before finishing with a quick survey of some of the issues arising from the cases. Enforceable undertakings were first introduced into Australia in 1993 when the ACCC was given the power under Section 87B of the Trade Practices Act to accept an enforceable undertaking from someone who had, in the view of the Commission, committed a contravention of the Trade Practices Act. And the second reading speech, when the then Attorney General explained the purpose for the introduction of that section, he made the following comments. It has proved efficient in some cases for the Commission to avoid prolonged litigation by accepting undertakings from businesses to cease particular conduct or to take action which will lessen the otherwise undesirable effects of their conduct. This approach has been used in appropriate cases for several years and has avoided considerable costs to both the Commission and the businesses concerned. At the same time, the outcomes have been demonstrably advantageous to affected third parties and to consumers generally. Recognising the importance and desirability of affording the Commission a flexible approach to the resolution of trade practices matters, the government has decided to provide legislative recognition of this practice, this will promote a greater public awareness of the range of options available in the administration and enforcement of the Act. And by providing for the enforceability of the undertakings, the scheme will remove the need to rely on means outside the Act to enforce the undertakings that people have given, should this prove necessary. So I thought that was helpful to set the frame for how enforceable undertakings have been taken up. They proved to be a successful and popular regulatory tool. Indeed, the ACCC accepted approximately 400 enforceable undertakings in the 7 years from 93 to 2000. And following the introduction of that power into the Trade Practices Act, a number of other Commonwealth regulatory bodies also lobbied for and were granted similar powers. So ASIC under Section 93A and 93AA of the ASIC Act, and more recently under the National Credit Act. APRA under the SIS Act, Superannuation Industry Supervision Act. CASA under the Civil Aviation Act. ACMA under its various Spam Act, Broadcasting Services Act, Telecommunications, Do Not Call Register, all the things that they regulate. AUSTRAC under the Anti-Money Laundering and Counter-Terrorism Financing Act. The ACCC also has that power now under the Water Act, and most recently the Registrar of the PPSA has the power to accept an undertaking. In addition, state government departments and statutory bodies have been granted similar powers under their relevant legislation, and I've set out some examples, but including in relation to industrial relations, electricity safety, even legal services commissioner, and environmental protection legislation as well. The Australian Law Reform Commission in 2002 did a review about securing compliance, civil and administrative penalties in the federal jurisdiction, and in that particular review, the Law Reform Commission noted that EUs were a mechanism that was unique to Australia. Although, of course, similar types of enforcement tools exist elsewhere. In America, the Antitrust Division of the Department of Justice has the power to enter into consent decrees, but there are a few differences there in that it's only binding once it's been submitted to the court and approved by the court, and the public has 60 days to comment on it before the court approves it. So that's quite a different regime. In the UK, there is also a similar tool, also known as enforceable undertakings, and I believe that they are quite a common route for director disqualifications, and were in fact introduced because of delays in getting director disqualification orders through the courts system. So if you accept an enforceable undertaking, you can start your disqualification period sooner. Just might move down to the legislation, which is set out on page 3. I've extracted Section 87B of the Competition and Consumer Act, which thankfully is in identical terms to the former section of the former Trade Practices Act. And I might go through it in some detail, just so that we're all clear on what we're talking about. So in subsection 1, it provides that the Commission may accept, so it's a discretion of the Commission's, a written undertaking, and it must be given by a person for the purposes of this section in connection with a matter in relation to which the Commission has a function or power under this Act, and then carves out Part 10, which, in case you're interested, is about international cargo liner shipping. So unlikely to arise for me anyway. So those words, in connection with, make it a very broad power. It merely has to arise in connection with. Subsection 1A was inserted in 2006 and just specifically provides for the Commission to accept a written undertaking in relation to the merger and the merger clearances and authorisations part of the Act. Subsection 2 sets out that the person may withdraw or vary it, but again they require the consent of the Commission to do so. And then under sub 3, there's the test by which the Commission may apply to court if they consider that the person who gave the undertaking has breached any of its terms, and they may apply to the court for an order under subsection 4. And then under subsection 4, it sets out the test that if the court is satisfied that the person has breached a term of the undertaking, then the court is enlivened to make any or all of the following orders. So those include an order directing the person to comply with that term of the undertaking, an order directing the person to pay to the Commonwealth an amount up to the amount of any financial benefit that they have obtained directly or indirectly and that's reasonably attributable to their breach. Any order the court considers appropriate to direct the person to compensate any other person who's suffered loss or damage as a result of the breach, or any other order. You'll be delighted to know that Section 93AA of the ASIC Act is in substantially identical terms, so I won't read it again, although it omits the part specific to the Trade Practices Act or Competition and Consumer Act. And ASIC has a further power under Section 93 single A, which is specifically for accepting an undertaking for a responsible entity of a registered scheme. So given that the provisions in the ASIC Act are clearly modelled on those already existing in the Trade Practices Act, the cases regularly cross-refer to each other, both those cases arising under the ASIC Act and those arising under the Trade Practices Act. Sorry, I keep calling it Trade Practices Act, it's just quicker to say. I might, having gone through it in such detail, I might skip the section that sets out the features because I've already taken you to those things. Although I would mention that you cannot compel someone to give an enforceable undertaking. It's a voluntary act, and likewise a regulator cannot be compelled to accept an enforceable undertaking, although I will take you to some cases that might suggest otherwise, certainly in terms of the AAT's power to force ASIC to accept an enforceable undertaking. But unlike an undertaking that's given to a court, there does not need to be any court proceedings on foot for the regulator to accept an undertaking. And a breach of an enforceable undertaking does not amount to contempt of court, but if you've taken the matter to court and you've got an order that a person should comply, then breach of that order obviously would be contempt. So, talking about the function of an enforceable undertaking in a regulatory regime reminds me of a saying of my father's that if the only tool you have is a hammer, everything starts to look like a nail. And if you've ever walked around the house with a hammer in your hand, you do look for things to hit. An enforceable undertaking, I've given you an image there of the enforcement pyramid, which sets out the hierarchy of options that are frequently available to regulators. And without going into theories of enforcement and compliance, there is certainly advantages in having a hierarchy of options which you can ratchet up or ratchet down depending on the situation that you're in, but which have difference in severity of outcome for the person who's being regulated. And the appropriateness of a particular remedy will depend on factors such as the seriousness of the breach, the compliance history of the person, and the impact of that breach on affected people, the community at large, and the general compliance with the regulatory regime. So, within that pyramid, enforceable undertakings would probably be third from the bottom, but they're seen as a flexible, cost-effective remedy which is able to influence behaviour and encourage a culture of compliance for the benefit of all participants. And they can also enable the regulator to deliver benefits that aren't otherwise available, such as providing compensation to third parties or donations to a relevant cause. So some of the ACCC's enforceable undertakings are quite good on this. There was the undertaking that a company called Go Drew Proprietary Limited gave in relation to their mislabelling of their eggs as organic eggs, when it was quite clear to the provider that at least 50% of those eggs were not organic within the meaning of being certified as organic. And as part of the undertaking, the company paid, I think, $200,000 or $300,000 to Organic Australia organisation. Similarly, under the environmental protection regimes, some of their undertakings can involve not only a compliance program, educating the staff to avoid in future destroying native habitat and particular plants. It can also involve, for instance, paying $100,000 to the striped legless lizard recovery team, or something like that. I looked up a picture of the striped legless lizard. It looks like a snake. Moving on to the next topic, being an overview of the policy of the ACCC and ASIC. For the sake of simplicity, I have merged their policy together. So please do not rely on this for the purposes of working out either of their policies, but go directly to their policy documents set out on their websites. But because there was such a lot of overlap between the two sets of policies, I originally set them out separately, and then it was unbearably repetitive. So According to the regulators, enforceable undertaking is only appropriate where the regulator has reason to believe there's been a contravention of the relevant legislation and has commenced an investigation into the conduct. So it's not appropriate for trivial matters. It's not appropriate to forestall an investigation. It is not considered appropriate in place of criminal proceedings. It's an alternative to civil or administrative proceedings. It's not appropriate to secure payment of a pecuniary penalty, a pecuniary civil penalty, because ASIC in particular believes the public interest is best served by a court determining whether a penalty is available, and if so, its quantum. It's not appropriate after a matter has been referred to another body, such as the CALDB or Financial Reporting Panel, Takeovers Panel, or even a delegate of ASIC for whether to make a disqualification or suspension order. The process involves negotiating with the particular investigating officer or staff member the possible offer and possible terms, although that person will not have authority to finally accept or reject that. And the undertaking only becomes effective when it's been accepted and signed by a person with appropriate delegation. And that's quite highly held. It's not likely to be the person you're dealing with at the first instance. In the drafting, there will be a negotiation of the terms that lead to what the regulator considers an appropriate regulatory outcome. And obviously it has to be more effective than that which could be got by a non-negotiated outcome. I've set out some of the critical considerations on page 7 for ASIC have been about whether it's going to be an effective regulatory outcome. That would look at the position of consumers and investors whose interests have been or may have been harmed by the suspected conduct, the effect on the regulated person's future conduct, is it going to change and improve compliance, the effect on the regulated population as a whole, and the community benefit in regulatory outcomes being achieved as quickly and cost effectively as possible. And again, the ACCC's broad objectives are set out about ceasing the conduct that led to the alleged breach, redress for parties adversely affected, implementing compliance measures to help prevent future breaches, and general education and deterrence, particularly in that industry concerned, by way of public awareness. Previous enforceable undertakings are not, in any sense, a binding precedent on what will be done in the future. There will not be an acceptance of an enforceable undertaking that denies the conduct or doesn't include details of the misconduct or doesn't at least acknowledge that the regulator's views about the misconduct are reasonably held. It would not be appropriate to accept an undertaking that sets up defences, imposes obligations on the regulator, contains self-serving statements, etc., etc. I might skim over, or publicly available, I should mention that. All enforceable undertakings, certainly for ASIC and ACCC, are publicly available on their websites, and they will not be removed from their websites even after they've been completed, although there is some scope to delete from the public register commercial in confidence material. That would have to be negotiated. Skipping down to... might skip over I've set out a template of the guide undertaking, but I'll skip over that, and also examples of the types of enforceable undertakings that ASIC accepts, and they're the type of things you would expect based on particular topics: corporate governance, auditors and liquidators, disclosure, takeovers. I might move on to the issues arising under the cases on page 11 and 12. Just to give, I haven't tried in any way to be comprehensive here, given the many years of case law, but I've just picked out a few issues that I thought were interesting. So in order to give effect to consent orders disposing of proceedings before it, after a matter has been resolved by entering into enforceable undertaking, the court held that it should not just note undertakings that have been given to the regulator without having regard to their content. So that the court should at least read them and be satisfied that prima facie that particular enforceable undertaking is one which the ACCC in this case was empowered to accept, although of course the court does not need to and should not make a positive finding as to that fact. So that was in the ACCC and Woolworths. Also, when a court is asked to make orders or to accept undertakings proffered by, again, a consent order, directing an entry which has contravened a provision of the Trade Practices Act to institute and maintain a trade practices compliance program, that particular program must bear a proper relationship to the contravention. So in the ACCC and ZTech computer case, the compliance program which was proposed and was part of the enforceable undertaking was for a program covering the entire Trade Practices Act rather than just the specific sections that had been the subject of concern. So it does need to be tailored to the specific situation. In terms of what the court has held that it was in the Trade Practices Commission and Q Designs, the court held that it was not appropriate to express a view that the regulator should have accepted an enforceable undertaking in place of taking court action, since the court had no involvement in that process. But the question about whether proceedings were necessary and that the regulator should have instead have accepted an enforceable undertaking might be relevant to the question whether the court should apply under Section 19B of the Commonwealth Crimes Act, should apply that section to discharge offenders without conviction. Again, it's been held that whether or not proceedings were necessary and the regulator should have taken an enforceable undertaking instead might be relevant in the question of costs for the regulator. So there were a pair of cases, the ACCC and Apollo Optical and the ACCC and Monza Imports, in which this question was raised. In both those cases, the regulator was able to persuade the court of the reasons why an enforceable undertaking was not considered appropriate in those circumstances, and so costs followed the usual rule, but that threat obviously remains. And again, in ASIC and Bridge Corp, the court talked about the circumstances in which, although ASIC could have accepted an enforceable undertaking, in circumstances where a useful and beneficial purpose is served by constructing a regime of compulsion based on orders of the court and the sanctions that follow non-compliance, then the court can make those orders. I flagged earlier the fact that the regulator has to accept or choose to accept an enforceable undertaking, and that is the case. But in the series of cases of ASIC and Donald and Dawes and ASIC, the federal court held that while the AAT does not have power to review a decision to refuse to enter into an enforceable undertaking, that's not one of the reviewable decisions, because it has the power to review ASIC's decision to issue a banning order under the Corporations Act, it also has the power to step into ASIC's shoes and remake that decision by instead accepting an enforceable undertaking on behalf of ASIC in place of a banning order. So ASIC reluctantly entered into those enforceable undertakings. How am I going for time there?
Just about.
Right. Excellent. I might just take a couple more cases. In Sage and ASIC, the court found that, although the person had offered to give an undertaking that would not be, and not to continue to provide financial services, that was not an adequate alternative to a banning order because it couldn't be recorded on the register, which could be searched by the public. In terms of interpretation, at 44, I set out a couple of cases about how, because they're given under a statute, an enforceable undertaking is to be regarded as a statutory instrument, Australian Petroleum Proprietary Limited ACCC, and again, because it has a public purpose and members of the public can rely on it and upon their terms, to interpret them, the court should use principles of construction of legislation rather than contract principles in toll holdings. I might stop there because I don't think the last case So exciting. Thank you so much.
I'm all for timeliness. Thank you, Aimee. On behalf of everyone here, could I thank David and Aimee for their papers and their presentation. You'll all be aware that to do a paper such as the papers presented takes an enormous amount of work, and we're very appreciative of all of that work and your time today. Thanks very much.